Which is why they are saying it is academic, don't deal with it. Our speaker will decide. Now we have a new speaker. And now we can't remove him because they have the majority now. So please, please, I beg of you, this is not about today. This is about tomorrow. Don't board the issue, and say it doesn't arise. It will arise time and again. No, don't allow the verdict of the people to be toppled or an elected government to be toppled in this fashion. That's the fundamental principle. A government. Let's be clear. And you can't discharge your functions as a deputy speaker. Means I can't discharge under the 10th schedule. So that's
your
clear.
Simple point is that there was no complaint under 10th schedule. Where is the question of a notice given?
Exactly. And how is this academic? The whole purpose of it was to paralyze the speaker. Purpose of it was to ensure that I do not deal with the disqualification petition when it comes. And they knew it was coming. In politics, there is no secret.
There was already
what happens at one end is known to the other person. So somebody must be drafting the petition, and they must be knowing it. And let's draft a letter, date it 22nd, date it 21st, and send it to them. That's it. This is practice.
Obviously, everybody knew what was going to happen.
So,
who doesn't
say that this all is
they are times ahead of times to come.
Yeah.
It's all. Who doesn't know? Even citizens know about it. Forget about legislators.
That's right. Even citizens know. So therefore, let's be clear. The whole initiation of the exercise.
The 10th schedule now has been internalized by the political establishment. So they knew exactly.
I said that in my opening. I said that in my.
It's been internalized. They also knew exactly what's going to happen. It's like everybody is, it's like a chessboard. Everybody knows what's the next move.
Yes. Now, let's look at it from another standpoint. I'll come to the 10th schedule later.
Yes.
Another standpoint. Well, it's under the 10th schedule now, even if the majority defects, it will still be defection. There is no concept of majority, minority under the 10th schedule anymore. The only concept is of merger.
Merger, that's the only thing.
So to say that the majority, we are 40, is no defense under the 10th schedule.
But this is not a case of merger also, as
it's saying. It's not their case of merger. So to say, I've been hearing this refrain that we are 40, they are X, it makes no difference. That is why para 3 was removed. These are very serious issues. You can't apply Govt Rebia in this fashion. And therefore, my Lord put it to me, if you have lost the plot, we have not lost the plot. Because the 10th schedule itself allows me. There is no defense available. Which is why they don't want this to go on. Which is why they are saying it is academic, don't deal with it. Our speaker will decide. Now we have a new speaker. And now we can't remove him because they have the majority now. So even if we give a notice, we can't remove him because they've toppled the government. See the serious consequences of this. And what moral principles are we talking about, these are not conscientious objectors, like in Soviet citizen wars, in Russia. These are conscientious defectors, where they lay their conscience on a platter and depends on who bids the highest. Let's not make these moral principles in this. We know what happens. So, please, I beg of you, this is not about today. This is about tomorrow. Don't board the issue, and say it doesn't arise. It will arise time and again. Elected governments will be toppled. And no democracy in the world allows this to happen. Why do you allow the party to use the 10th schedule? In fact, the process must be, this is my and when I argue the merits, the process must be that an elected government must continue till the disqualification petitions are decided. If they are disqualified, that's the end of the matter. Your lordship is there to protect them. If they are not disqualified, the elected government will go. But do not allow the 10th schedule to topple an elected government. And do not interpret 179, 181, the moral principles that Justice Misra talked about, to allow this to happen. It's far too serious. It's not just, I'm sorry, it's not just a narrow interpretation.
Sorry? Yeah. Yes.
So let's kindly see it. Look at the Lok Sabha rules on removal of the speaker. It's part of the compilation. 3C.
Mr. Sibbal, ultimately, equally, what your submission is, therefore, give free rein to the speaker.
No,
Free rein to the speaker.
No, Malaj.
Without imposing any restraints.
No. Please don't do that. And I'll tell your lordship what the solution. What's the free rein, Malaj? He cannot deal with a disqualification unless there is a disqualification petition. He has no right to suo moto deal with it. Malaj, the disqualification petition will come under 2.1a or 2.1b. 2.1a, if he violates the whip, Malaj, what's the free run for the speaker there? In this, what happened? On the 3rd of July, at the time of the election of the speaker, the whip in the house was Sunil Prabhu. He had not been changed. He directed that the Shiv Sena candidate should be voted for by these defectors. They voted against. They elected the BJP candidate, not the Shiv Sena candidate.
Interestingly, both your argument and the argument of the other side, which espouses the Nabam principle, rely on the same principle, namely the importance of the speaker. They say, because of the importance of the position of the speaker, it's important that you must exclude any possibility of conflict of interest.
But where's the conflict?
You say that in view of the importance of the position of the speaker, allow him to decide.
No, I say don't allow an elected government to be toppled in this fashion. Mothers, no. Don't allow the verdict of the people to be toppled or an elected government to be toppled in this fashion. That's the fundamental principle. A government stands elected till it is removed, and it cannot be removed through the machinations under the 10th schedule. That's my contention. Let's forget about the speaker or no. This is the fundamental principle of democracy. And if you have violated the 10th schedule, allow the speaker to decide. He can't decide if there's a whip that has been issued and somebody votes against the whip. What leeway does the speaker have? You are giving a leeway to the other side, disabling him, toppling the government, and then not deciding the matter. I remember, Manoj, when the Rajasthan matter came up on this court, Justice Arun Misra, on a daily basis, used to monitor the disqualification proceeding. On a daily basis, when it came to Rajasthan. When it came to Goa, for 2.5 years, we kept on telling the Chief Justice, please have the matter heard, please have the matter heard. Where do we go? These are all nice principles of law, but you have to have a functioning, working democracy.
Rhetoric, not law.
This is why it's far too serious, Manoj. The fundamental principle is keep an elected government that is already elected in place, keep it in place till such time as it can be thrown out. Of course, it should be thrown out, Manoj. And that is not to be decided in the legislature. Manoj, kindly appreciate what is happening. This is another very interesting thing. And it's something that your lordship should think about. 5 people in Goa, say 2 of them or 3 of them are taken over by another party. The government falls. Or 4 of them are taken. The argument is that under the principle of merger, since they have merged with another party, right? Now, what is the party? The Congress party still remains. Those three of only legislators have merged. The party still remains. It happens in the Rajasthan also. The BSP people, Mullah, have merged, but the BSP still remains. So what we are now doing, we are allowing the manipulation within the Legislative Assembly to topple governments through means that your Lordships and I are aware of. The purpose of the 10th schedule was not to allow that to happen. Not to allow that to happen. That was the purpose of the 10th schedule. Previously, it was 1/3 in paragraph 3. They said we removed the 1/3 because it was being used to topple governments. Now there is no paragraph 3. Now a bogey of majority is raised. Because if a minority can be bought, majority can also be bought. But to what end? To topple the government. And not to allow the speaker to decide the matter. Whereas who can say, person sitting of one party in Guwahati, saying that he has not voluntarily given up membership of the party? It stares you in the face. He is passing resolutions from there that I remove you from chairmanship, I remove you from this office, I remove you from that office, I appoint myself. That's not supposed to be voluntarily giving up party. They are all arguing on the assumption that they are right when they say that there can be no disqualification for these acts. That's how they are arguing. And that the speaker, deputy speaker will malafidely say that they stand disqualified. You can't make a constitutional assumption like that. That's the assumption they are making. See what the speaker is doing. He only gave us 2 days notice. Why did he give you 2 days notice? Because the facts stare him in the face. That's the reason for the 2-day notice. Now, your Lordships, when dealing with the merits of the matter, will decide whether that was enough, not enough in the facts of the case, but that's on merits. But the issues are far larger. And if this is allowed, it can happen anywhere, and it will happen. It has happened. This is not the first time. Now, having said that, kindly come to the 10th schedule for a minute. This is the point I was making. Even when the motion is in the House, he may not be willing to move it. So there can be no injunction for him to continue with the 10th schedule and the proceedings. Because the resolution, let me tell you, I have some experience in Parliament. Let me tell you what happens. Whereas what happens is that whenever a resolution...
But according to you, there can't be any injunction at all, irrespective of the stage of the motion. Right?
Yes, because that is to him. This third...
Even if it is admitted, there is no bar on
No.
Even during the 7 days.
Yes. Well, I tell you, Lordships, why? Well, the 10th schedule deals with strangers. The motion deals with him. The 10th schedule deals with third parties. The motion deals with him, so he cannot preside on that particular day when it's under consideration. Well, what has got to do with third parties? Now, these issues were never discussed in Nabam.